Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And what I have going here is not... Yeah, of course I want to open it with that. What are you thinking? All right. Just a second. We've got a little court document to go through today. And I'm going to use that to talk about some issues that I have with the old criminal justicery system thingamajig. Justice-a-madoo. You know what I mean, right? Like there's these protections that we have, constitutional protections, I think they're called, and those just seem to, I don't know, become less and less important when the courts or cops decide that they already know what they think the answer should be. Those protections kind of erode away. And because the person is guilty of whatever they did, we kind of go, well, maybe they shouldn't have done that, for example. So too bad. Too bad for them. It's a weird sort of thing, and I don't really like it. I don't really like it. Let me get the document pulled up here. Sorry about that. Let me get this. Here we go. There we go. There we go. That was a smooth transition right there. We can, this thing's got to shrink down just a hair. No, not. I think that's our sweet spot. Is that our sweet spot? There it is. There it is. Okay, we're getting this thing figured out. I'm remembering how to do this sometimes. So thank you for joining me tonight, of course. If there are a couple ways to interact with me during our lovely discussion, one of them, of course, you can see happening already, is the super chat function through YouTube. The other one is to use the justice chat function, which is a link in the description of the case, and that will send the money through PayPal or Streamlabs or whatever, and it will skip YouTube because I don't know if those dirty scumbags deserve any money. Wait, I do know. They don't. They don't. So the less we give to YouTube, the better. But I will, of course, appreciate anything that you send, no matter which way it goes through. And all of them will be read on stream and all of that stuff, and I will answer your questions. Or address your comments or concerns. If you want to air grievances, you're welcome to do that via money as well. Some people just choose to make dummy accounts and try and post negative reviews about my business. But, you know, when they do that, they should really pay attention to what they do with their dummy account, because sometimes you can tell exactly who it is. You know who you are. Good try, sweetie. Good try. Landon Mack and James says, why won't Dick tell us he eats ASS? I don't know. I don't know. I mean, I think if you are prone to eating booty, you should say it, right? And be proud of it and wear it on your beard as Bunty did. Let's see. Christopher Nicholson says, I know you're coming to K-Town. Are we going to meet somewhere? Logistics. Well, I'm going to the fight, and I'm going to be at an Airbnb. Other than that, I don't know anything else about Knoxville. So as for logistics, if you want to join in on the festivities, if you're going to be at the fight, obviously we can see, I'll be happy to meet up with people there. Otherwise, I assume there will be some sort of bar action happening somewhere. And a great way to keep up with me would be like a Twitter DM or something like that. But I'm going to probably be going with the flow of the crowd, wherever, like, you know, Ralph, Dick, Worski, where any of those guys are going to be. That's where everybody's going to be. It's not like I'm going to be somewhere different. So, you know, that's that. I would, I'll love to meet up with anybody, have a drink, share some stories and laughs. And just the only thing will be getting a hold of me. I will have my phone. So obviously I'll be available on Twitter and stuff like that. So just DM me and we can work out a meeting or whatever. Okay. Let's see. A couple things to answer here. There are a couple questions that I want to get out of the way right away. Okay, NE Dynamo asks, what do you think about the other YouTube lawyer filing an FTC complaint against Patreon and PayPal? That, for those who are not aware, I think most of you probably know, Lior of YouTuber Law has gone ahead and said he will be filing an FTC complaint. My understanding is that he has not filed the complaint yet. On his website, he mentioned that he will be doing it as one lawyer, and typically it's a team of lawyers. God, sorry, I got stupid cables in my way. Typically it's a team of lawyers with a staff, and so he's going to be doing it himself. I don't know if he's actually filed it or anything like that, but it sounds like that's an upcoming project of his. What do I think of it? I think good luck. I don't know that the FTC is going to... I think his theory is a group boycott theory, which is good. It's a good theory, and it allows for people who are doing anti-competitive practices without having necessarily a monopoly. But it's when you work with another person to keep out a competitor of one of the people in like a cartel. Cartel is an ominous word that I like to use for it. But Patreon and PayPal aren't the same company by any means. They're nothing. They're not even in the same industry. PayPal is a processor, payment processor, and Patreon is a website that accepts payments for sure, but it doesn't process credit cards or anything like that. It doesn't really work with banks. I mean, all of their banking transactions are done through Stripe or PayPal already. So they're certainly aligned, but they're not within the same industry. So it's not like a monopoly situation. This instead is where you get multiple players to freeze out someone who's competing with one of them rather than all of them. Good luck. I don't think... I haven't analyzed the case law, and I'm not an expert in antitrust. I think any kind of action like that has got a long way to go before it will be successful. But best of luck to him. And I said it on Twitter, and I'll say it again here. If there's anything I can do to help Lior in the action, I'd be happy to lend my assistance. But I think he's probably going to handle it on his own. But if there's anything I can do, I'd be happy to chime in. I don't know. I don't know what he might want. I doubt anything. But some people have said I should do it too. Some people have said, what am I going to do? I don't. That's Lior's fight to fight, and he can do that. I don't have any plans to like one up him or anything. I will just offer my support and encouragement. And again, anything I can do to help out, I will do. But he hasn't asked me, and I highly anticipate that he won't. Okay. Siren Jag says, I donated $2.27 with Marla Gibbs and Jackie Harry. Oh, thank you. Thank you. Let's see. So next, there were a couple more chats I want to get through before we dive into this case. Weefex says, what am I drinking tonight? Well, right now I've got sweet tea. I'm about to decide what to dig into here. I think I'm going to go with the gin. This Fid Street gin. And we're going to use one of these Norland glasses. Oh. Yeah, I think... So someone in the chat, King Mob, said Legal Eagle. I'm pretty sure Legal Eagle is actually an antitrust attorney. I'm not even joking. I think he is. But he's got such vanilla, boring opinions on things that he's probably like, no, I love Patreon and Stripe and PayPal. They're the greatest companies on earth. Why wouldn't anyone like them? So I don't think you should count on any hope from Legal Eagle. BetterHelp is a great company, and in Discord, forcing arbitration on you is just fine. Don't worry about it. So maybe. Let's see. Would you try playing Kill Team if I send you some Grey Knights? I'd love to play Kill Team. I just don't have anyone to play with. I'd be happy to. Love to try it. Christopher Nelson says, banned from Twitter 4 times. Sapphire, by the way, is a great place for fancy drinks. Sounds good. Banned from Twitter. So it's going to be hard for you to DM me. Email me. Email me some contact info, and I'll try and keep in touch with you. Rekieta Law at rekieta.org is my email. I'm hoping that Rekieta Law has a team of friends pretend to break into his vault and kill the stuffed dog. That'd be good. Okay. Gin. Okay, guys. Let me let's get started on this. Let me give you the background information as much as I can. So this is a case. This is an order on a motion to suppress evidence in a criminal trial. So this is a pretrial motion, and the idea is to get the evidence collected from what the defense would consider an unlawful search, to go ahead and get the evidence collected from that unlawful search, and then anything that they found out because of the unlawful search and then went and found further, to get that thrown out. Usually, if you win on a motion to suppress, something like this, where you're suppressing all of the evidence, well, if all of the evidence is gone, then there's no crime. So you win. So it's a great thing. Every criminal trial pretty much has a pretrial motion to suppress the evidence or throw out the case or whatever. Because it's, one and done. You win. So we'll read the facts of the case here, but this is the order on the motion to suppress. We don't know if they're going to be found guilty. They are. We don't know if they're going to be found guilty of the underlying crime, but this is, they've got the evidence. They presented the evidence as part of their complaint, as part of the probable cause statement and all of that stuff. But a jury hasn't seen this yet. So it's just a judge, lawyers, and any witnesses like cops or whatever who are involved in the search. God, sorry, I got a stupid wallet in my pocket. So this is the order here. So this is prior to trial happening, in the middle of the case, as it were, and they lose this motion. The motion is brought because of what they would call an unlawful search, and we'll talk about why as we start reading the facts section. But I'm going to say this probably several times during the show. And if it gets to be annoying, I apologize. But I'm going to remind you that if you did this to the cops, you would be in prison. Okay? You would be guilty of a crime and you would go to prison. If you did the reverse, so whatever the cops do to these people, if you did it to cops, even in the context of what's going on, right? Like, if they lied to you, well, that's fine. But if you lie to them, prison. All right? If they threaten you, that's fine. But if you threaten them, prison. Okay? So I'm going to remind you a couple times how important it is that our system is not designed to work this way. It's designed to work a different way. A different way that makes a lot of people very uncomfortable, because it means very guilty people get away with more crime. Simple as that. That's the price of our constitutional rights, is that we will be less safe and secure from our fellow man, I guess. And you'll see what the crimes are, of course. But we will be less secure, and the trade-off of that is that we will be more protected from a government than the person next door. That's the idea. And we don't want that anymore. For some reason, we don't want that. We think that the person next door is going to kill us. We think that. But the reality is that's unlikely. The government encroaching upon your freedom in various ways is going to it does happen constantly, but that is a much more likely outcome than you dying from a random encounter with any other person. I mean, certainly it happens, but yeah. So this is not how our justice system is supposed to work. But here we go. All right, so this is United States versus Philip Guidry. This is an Eastern District of Louisiana. Order and reasons. Before the court is a motion to suppress filed by the defendant Philip Guidry, seeking to exclude any evidence seized in Guidry's home on March 2nd, 2018, and any statements made thereafter on the ground that the search violated the Fourth Amendment. The government opposes the motion, shocker, and Guidry submitted a reply in support. On December 13th, 2018, the court held an evidentiary hearing. At the hearing, the government presented the testimony of Homeland Security Agent Thomas Smith. He's literally Agent Smith, who was directly involved with the defendant's arrest and the search of the defendant's residence, and Officer Jeffrey Carroll Hawley, who obtained completed consent to search and waiver of rights forms from the defendant's wife, Casey Guidry. The defendant presented the testimony of Mrs. Guidry. The government also presented audio of the recorded initial encounter between law enforcement officers and Ms. Guidry, and the defendant submitted a transcript of the recording. Having considered the parties' memoranda, the testimony, and other evidence elicited at the hearing, and the applicable law, the court issues this order and reasons. Keck7Go, or before we go on, Keck7Go asks, did Ramos retire because of Maddox? How much will his retirement affect Asterios' case? How bad do you feel for the next judge? Ramos most certainly did not retire because of Maddox. As stupid as Maddox is and as stupid as Landau is, Ramos deals with stupid people all day. All the time. Ramos retired because Ramos is really old. How much will his retirement should affect Asterios' case? It'll affect it greatly in that it'll probably cause a massive delay in the sanctions hearing, if I had to guess. But we'll see. We'll see. How bad do you feel for the next judge? Not bad at all. Not bad at all. I think that next judge is going to come in, read the relevant motions, and actually maybe be more appalled at what Maddox did out of the context. Because briefly, remember that the first thing the court was called to do in that case was a motion to suppress the speech of Dick and everybody else from their, according to the document, constant and ridiculous harassment of Maddox, right? So, and they had a 50-page document full of insults that had been made towards Maddox and Kevin Landau, all right? That was the first exposure that Ramos had to these two parties. Now, they averted it with an agreement where Dick said he wouldn't talk about Landau anymore or something like that, or wouldn't talk about Maddox anymore. I don't know the exact details. They averted it due to some sort of agreement, and because of that, you know, they didn't have the hearing. But I bet Ramos had started reading that document. Now, the new judge probably doesn't need to read all of that backstory. The new judge just needs to know what is in the complaint, what's in the sanctions motions, and then the letters and stuff that were exchanged. I think it actually, I don't feel bad for him. Ultimately, I don't think Asterios' case will be impacted in its outcome. I think it'll just be in time. And then moving on to Darking Deed says, if it means innocent people go free, more criminals should get off. Obviously, I want this because I've committed no crime and therefore innocent people being protected from false imprisonment is directly in my best interest. Absolutely. And lots of innocent people do go to jail because they take a plea deal, because the odds are stacked against them if they don't have hundreds of thousands of dollars to dispose. In frank, stark, brutal honesty, that's a true thing that happens. So it's not fun, but it's there. All right, so moving on. My video feed is mirrored. Let's see. Can't read Streamlabs. Oh, okay. I'll fix that. Sorry, I thought I was going to be clever. Let me fix that. I apologize. That's weird that happens. Okay. So I mirrored it on purpose to be consistent with the Hangouts. What I did not expect was that it would flip the Streamlabs. That's weird. That's a separate thing. That's laid over the top. I'm never going to understand technology. All right. Sorry, guys. I was trying to add consistency, and instead I ended up screwing up everything. Hopefully we'll find out on the next Streamlabs whether or not that worked. Okay, background. On March 2nd, 2018, state and local police arrested Guidry pursuant to an out-of-state arrest warrant for felony firearms violation. Smith testified that prior to the arrest, he had investigated Guidry for being a self-professed sovereign citizen. Now listen to the next... Yeah, the left side of my head is my left hand. The left side of my head is... There we go. Hey, what's up, Dick? Welcome to it. So listen to this next statement, because this is one of the fun statements that cops put into these sort of things when they testify. In Smith's 24 years of law enforcement experience, he knew that sovereign citizens, or preppers, typically stockpile weapons to prepare for doomsday survival. I mean, he could spend like 30 minutes on an A&E special and learn the same thing. But he lends his 24 years of law enforcement experience to that hot take. Jade Kitten, tonight is not going to be Greer. Tonight is this. Greer most likely will be next week. Holidays have kind of messed up Sriracha's and I's ability to sync up our schedules. So, okay. So yeah, sovereign citizens or preppers. Sovereign citizens are not preppers. Like they might be. There's a Venn diagram of sovereign citizens and preppers, and they have overlap. So just so you know, the 24-year expert on sovereign citizens confuses them with preppers and conflates the two as the same synonymous crowd. They're very much different people. Good job. Good job, experts. Smith testified that members of the community had made comments that Guidry's home was fitted with sniper holes and that Guidry had bragged about having guns. I like that guy. I like that guy. Smith also testified that he had conducted surveillance of the home and observed that it was fortified with industrial fences, dogs, and metal fortifications. Like, once this guy gets out, I think I'm going to call him. I need some consulting services. Although the law enforcement officers lacked a search warrant, Agent Smith testified he had probable cause to support a warrant to search the home for firearms. Because he said so. Right? He certainly had probable cause. He knew that he was a sovereign citizen. He heard some people say that this guy bragged about having guns and sniper holes. And he looked at his house and it had fortifications. What more do you need to search a home? What more do you need? What? Like, I'm trying not to. I'm going to hit my Zen meditation, y'all. Shortly after Guidry's arrest, Agent Smith and Task Force Officer Victor Marler of Homeland Security then approached Guidry's wife, also a convicted felon, at her place of employment to obtain consent to search the home. As evidenced in the 8-minute recording of the encounter, Miss Guidry admitted she was kind of expecting the officers upon their entry. Not illegal or unlawful or even indicative that you should be searched to expect officers, especially if your husband has been arrested. After informing Miss Guidry that her husband was under arrest for some weapons charges, Officer Marler said that they needed to get into the home and did not want to harm no dogs. Wait a minute. The chat's still backwards? Hold on. Where is that? Did I just complete? Where is that? Alerts. Oh, there we go. That was beautiful. This is my ploy to actually bleed out more and more donations through Streamlabs, is to get you guys to keep testing it. So I think I've got it fixed now. Oh, here, I think I can test it. This is fake. There we go. Whoa, hey, thanks, John. This is a test donation for $84. That was polite of you. I wish that was real. That's sad. Okay, let's see what that chat said real quick. That was Landonime. It says, I'm drunk as hell. I want you to get every single penny of this. You deserve it. From the bottom of my heart, thanks for all these streams. Happy holidays. I'm highly anticipating getting drunk with you on Weeb Stream. Cheers, my friend. Ochinchin Daisuke. Daisuke. There you go, buddy. Thank you. Oh, my goodness. Christopher Nelson, you can do Streamlabs just by clicking on the link in the description that says Justice Chat. All right. Okay. So this is such a critical part. Look, we need to get in the home. We don't want to harm no dogs, right? This is Louisiana, y'all. This is Louisiana Homeland Security. Never mind the grammar. They don't want to harm no dogs, right? Miss Guidry immediately explained that she had 2 Malinois dogs that were kind of aggressive. 1 husky and 8 Malinois puppies. That's a lot of dogs. Before Miss Guidry began to describe the location of her son's gun, Marler reminded Miss Guidry that she was, quote, a convicted felon as well, but that the officers were not interested in y'all. They're always interested in y'all. They're all legal advice. Every cop is really interested in you. It's like if you don't have attention from a girlfriend, just go talk to a cop. They're very interested all the time, no matter what they say. They want to know. Trust me. Like there is never any time a cop says he is not interested in you. He is. He's just playing the neg game, baby. He is all up in that business. He wants nothing more than to see every last dirty secret you've got. Just said you love dicks. Okay. All right. Then Marler told Miss Guidry, we talked to him already, and he would know what's in there. We just need the verification. We talked to him and he told us, prepping. He told us everything. You know, and we told him we don't want to involve you because you still got work. And you have a child to take care of. Here we are involving you, right? Here we are. We don't want to do it. We don't want to. You got that kid to take care of. Just remember that, Miss Guidry. Following his arrest, Guidry had not told police anything about firearms at his home. To the extent that Marler's words can be understood otherwise, Smith admitted at the hearing that it would have been a lie. So, Smith says, look what he's saying. He's not trying to lie there. But if it comes across that way, then it was definitely lying. Because cops can lie to you. And just a reminder, if Guidry had lied to them, arrested, charged, convicted. Lie to Homeland Security? Who the hell do you think you are lying to Homeland Security? Darking D says, is it not a cop's job to be interested? I mean, at minimum, it's their job to take your concerns seriously. It's not just that they take your concerns seriously. It's that they're very concerned for you and taking you seriously. Landoname says, tell Dick to admit to me he eats butt. Is he here? Tweet me, Dick. I'm coming for you. Tell me now. You can't hide. So, Dick, if you're still in the chat, Landoname wants to know. He wants you to admit that you eat booty. So, there's that. Let's see. Okay, so he admits that it would have been a lie. Returning to Miss Guidry's encounter with Smith and Marlar, Miss Guidry then tearfully admitted that she had been separated from Guidry, sleeping in a separate bedroom in the house, and shortly thereafter described 2 more guns in the home. That's nice. Now she's in tears, right? Because you got that kid to take care of. Remember that. Remember that you got a kid to take care of. Marlar then asked if Miss Guidry would give her consent to search the home and accompany them to do so. Again, tearfully, Miss Guidry responded, okay, are y'all going to take me in? If you are, I need to make arrangements for my daughter. Marlar said I can't promise you anything, but with your cooperation, we know the DAs. We know everybody. Guys, no, thank you. No, you cannot have consent to search my house. Thank you. I'm at work. Please leave me alone. Thank you. That's it. That's your answer. If a cop ever wants to search you or anything, no thank you, officer. You do not have my consent. They're likely going to do it anyway, but don't make their job easier. Because once you give consent, it's all gone. It's all gone. You're throwing the biggest Hail Mary in the world once consent's involved. Okay? No thank you. They do it anyway, great. Don't fight them. Don't do anything crazy like that. Don't be obstructionist. Don't get yourself shot. Just say no thank you and then make them get their search warrant. They're going to get it. They're going to get it anyway. But then you can fight it at least. Can't promise you anything, but with your cooperation, we know the DAs, we know everybody. Remember, James Comey told you that the FBI cannot make recommendations about criminal trials, right? Like, oh, we know the DAs, we know everybody, but the DA is going to make the decision anyway. The DA is making that choice, not the Homeland Security grunt. Smith responded that they would not take her in or trick her into doing something that would give them reason to arrest her, but that her cooperation was the smoothest way to do it. Avoiding cutting up your fence to get in, using a battering ram and bashing in your door to get inside, or potentially shooting or hurting a dog on the way in. Wouldn't want to kill those pups. The group made plans to leave. Miss Guidry permitted the officers to use the restroom, called her boss to let him know she would not be returning to work, and gave her contact info to her coworker. Miss Guidry had initially agreed to ride with the police, but because she could work from home, drove herself in her own car and the police followed. I don't know what her having to work from home has to do with driving her own car and having the police follow, but the police officers had requested that Miss Guidry put her purse in the trunk of her car for the ride over to her home, and she complied without objection. There is conflicting testimony as to when Miss Guidry signed the consent to search and statement of rights forms. Officer Holly testified that upon Miss Guidry's arrival and in the driveway, he read her a consent form which she and he signed at 11:12 a.m., as denoted on the form. Holly testified that Miss Guidry was cordial and helpful, seemed to have her wits about her, and was less nervous than others in similar circumstances. Holly testified that Miss Guidry then opened the gate, secured the dogs, entered the home, and directed the officers to the bedroom and the mattress under which an automatic weapon was hidden. The statement of rights form was completed later, also signed by Holly and Miss Guidry, and shows that time it was completed as 11:33 hours, 11:33 a.m. It bears a handwritten note that states search begins 11:20 a.m. Thus, As Holly remembers it, Miss Guidry showed the officers the gun in the bedroom shortly after signing the consent to search form, but before executing the statement of rights form. Miss Guidry testified that she does not remember signing anything until after showing the officers a gun in her husband's bedroom. Don't worry. It's just inconsistencies in the expert statements who do this all the time, wrote it down in their own logbooks, and had the form signed. They're the ones who can't remember. If you and another person were involved in the same thing and you had inconsistent statements between you, that would look like guilt. That would be cause. That would be worse for you. For them, it doesn't matter. It doesn't matter that their statements don't seem to match up. Doesn't matter that not only, oh, hey, I got this parrot head. Doesn't matter that that not only do their statements not match up, but that they seem to be in conflict with the other party that was present's statement, Miss Guidry. So, Anonymous masked you for $2. Says the Chad Legal Eagle inspires fear within the law macaw. How dare you? How dare you? Oh my gosh. Okay. The officer seized 6 firearms on March 2nd, 2018. On March 6, 2018, law enforcement again contacted Miss Guidry to obtain consent to search the Guidry home. On March 7th, Ms. Guidry permitted the second search, during which the Bureau of Alcohol, Tobacco, and Firearms seized ammunition in a surveillance DVR system. No charges followed the second search. Thereafter, the grand jury charged Guidry in a 1-count indictment for being a convicted felon in possession of a firearm in violation of 28 U.S.C. 922 G1 and 924 A2. So, guys, what he did is a crime. Make no mistake, if you are a convicted felon and you have not received an expungement of your federal criminal conviction and permission from ATF, owning a firearm is unlawful for you. But notice what he was not indicted for. Anything else. Anything else. This guy wasn't running around threatening people. This guy, he's not charged with it anyway. He didn't use a gun in a robbery. He didn't shoot at someone. He didn't brandish a gun on the street. He didn't get in a fist fight. He didn't bite or, he didn't do anything that we know of. We just know that they're just looking at this guy because he's a prepper or a sovereign citizen, leveraging a threat of violence against a dog and an implicit threat of taking a child away under state force, and then getting a consent to search the guy's home. That's what's going on. It's cool, right? Super Iron Bob, I missed your justice chat. I did? Oh, is that Okay, so that was from Darking D, I'm guessing. It says probable cause to support a search for firearms. Owning firearms isn't a crime. Well, it is if you're a convicted felon. So that is a crime. And then Darking D, if I didn't cover this, it says, is it not a cop's job to be interested? I mean, at minimum, it's their job to take your concerns seriously. Yes, it is. It is there. But what I mean, and I think I said this, but what I mean is that they are very much interested in not taking your concerns seriously. Well, it's actually not their job to take your concerns seriously. And if you want to have more info about that, I actually did a video on Castle Rock versus Gonzalez a long time ago. And the title of that video is Why the FBI Won't Take Responsibility for the Parkland School Massacre. Okay? You go watch that, and you'll find out that it is not the cop's job to take your concern seriously, according to the Supreme Court. Or to take your concern at all. We actually aren't sure why they're there, according to the Supreme Court. It was from John. You made it real. Oh, that was... Oh, thank you. I did think it was the fake one. So John donated $84 and said this is a test donation. Wow, thanks, buddy. I thought that was just my Streamlabs event telling me that it was the fake one. I really appreciate that. Thank you. Thank you. Okay. So then we've got Darking D saying, hey, you know how every American intelligence agency should be disbanded and reformed without one single person from the former agency? Yeah, good idea. Glad you thought of it. Lawyer with that law money who knows of her people with money to lobby. Who knows other people with money to lobby. Well, yeah, that would be great. Congress can do the same thing too. Absolutely. Landoname says, everyone tweet D Masterson and get him back here. I don't know if that's a way to get back here. Get him back. Keck7 Go says, would Legal Eagle speak out against shooting of minorities and dogs? I haven't seen him do it. Best I can tell is Legal Eagle is in full support of shooting dogs and minorities. So who knows? Who knows? Maybe he needs to issue a statement on it now. Landoname says, get him back. Let's make him admit he eats beehole. Epification says, I'm slightly paranoid engineer and a military and weapons enthusiast. If you need help hardening your property, I can help. Those are credentials, right? Those are good credentials. Those are good credentials, buddy. I like it. Thank you, Super Iron Bob. Merry Christmas. Right back to you, buddy. That was beautifully done. So seamlessly trolled that I had no idea that it actually occurred. It was expertly done. Okay, so this is section 2, the pending motion. Guidry, so here's the legal argument that's been given as the judge reads it. Guidry moves to suppress the evidence seized on March 2nd and any statements subsequently made by him or his wife on the grounds that the warrantless search violated the Fourth Amendment. Guidry contends that the officers lacking probable cause, and I think they did lack probable cause, and that's why that consent was so helpful to them, coerced Ms. Guidry into showing the officers a firearm in the home by making misrepresentations and threats. Guidry says the officers concocted Guidry's confession to possessing firearms when they informed Ms. Guidry he had, quote, told them everything, because at the time of his arrest and booking, Guidry had only made general remarks about his religious and political beliefs. Supernova, Merry Christmas back to you, buddy. Further, because Ms. Guidry was a convicted felon, Guidry suggests she did not believe she could refuse consent, implying that her cooperation was forced by the threat of her own arrest. Guidry also essentially contends that the officer's comments about shooting the dogs and Ms. Guidry's need to care for her child constituted a veiled threat of arrest such that her will was overborne. And this is absolutely what happened. Make no mistake. No matter what they say, you got those dogs, you got that kid. That's a nice dog. It's a nice dog you got there. That's a nice kid you got there. Be ashamed if someone were to come in and take it, right? That's what happens. They're going to misdirect on the stand and say that that's not at all what they meant, but that's exactly why they said it. Cops are the best, the absolute best interviewers and interrogators in the world until they get to court, and then suddenly they will argue infinitely at how bad they are at manipulating people into telling them information. It's amazing. If you listen to the cops in court, they're all the worst at doing the job that they're really, really good at. They can constantly manipulate people into telling them what they want to hear or what they need to hear or getting a certain line or a confession or consent out of people. But once you get to court and start asking them how they do it, well, I don't know. I mean, it was just happenstance that I said a bunch of magic words that force someone to do it. It's just, whew. God. Additionally, Guidry argues that the officers never informed Ms. Guidry of her right to refuse consent or terminate the police encounter, which contributed to her reasonable fear as, quote, a woman confronted by 2 male law enforcement officers who announced they had just arrested her husband. Why are they out there harassing women, right? Works for everybody else, not you, buddy. And finally, Guidry submits that the officers had ample time to obtain a warrant while Guidry was arrested and Miss Guidry was at work, and they should have done so. That's absolutely true. Typical Dissident says, OG Patreoni, would you ever entertain a video covering current status of piracy laws, potential history, and how good an idea it is to have boomers legislating black magic to them? Yeah, I would love to do a video like that. I need to do some research on it. It's not my area of expertise, but I would love to do that. Maybe I can find a good expert on it to guest. I'll see. If you guys have any ideas on who might be a great expert on that, let me know. Darking D says, you know, this is how Killdozer happens. And absolutely, this is how Killdozer happens. It's literally how Killdozer happens, too. Okay, yeah, they had ample time. They should have gotten a warrant. Yep. Alternatively, Guidry contends that consent was never given prior to the search, suggesting that the time stated on the consent to search form was fabricated. That never happens either. Never happens. They never fabricate a handwritten form. Why would they do that? Why would they lie about what time it is? I mean, I don't know. And then Miss Guidry only signed the consent to search form after the police seized the firearms. Shoot, I forgot to get that form signed. Just have her sign it now, along with the explanation of rights. We'll put the time a little bit before we started. It'll be good. In either instance, Guidry maintains that the firearms and statement should be suppressed as fruits of the poisonous tree. The government claims it has carried its burden to show that Miss Guidry, as a person with authority, provided oral and written consent freely and voluntarily, ignoring the fact that she had been separated from her husband by her own admission, and that actually might constitute some sort of lack of authority. A little bit, in all honesty, but, you know, not legally, not cut and dry. But I would make the argument, and I think that maybe Guidry's attorney should have put that in there also, that she was unable to give consent as they had been separated, as she admitted to the police at the time. But, you know, what do I know? First, the government contends that Miss Guidry's oral consent was voluntary. Thus, the timing as to when Miss Guidry gave written consent is superfluous. Nonetheless, the government claims that no search began until Miss Guidry signed the consent to search form. Try it on the cops. Moreover, says the government, probable cause existed to obtain a search warrant of the home such that suppression is unjustified. We had probable cause. We didn't have a search warrant, but we could have gotten one. We could have gotten one. You can't go back and re-examine the facts as a neutral audience now, but we could have. We could have done it, and that's good enough. In support of voluntariness, the government analyzes the 6 factors applied by the Fifth Circuit. At no point was Miss Guidry under arrest, right? Convicted felon, 2 people, says we just arrested your husband. It would be a shame. It would be a real shame if we had to, you know, take you in and you got that kid to take care of. And sure, we'll follow you. Just put the purse in the trunk. Put the purse in the trunk so you don't get out of the car and leave with your purse. Because make no mistake, there's a reason they asked her to put her purse in the trunk. Because if she put the purse in the front seat and she could get out of her car and make a run for it or get somewhere or get, you know, something like that, lose the police and make a quick getaway from the car into the bushes or something, and she had her purse, that extra delay, it's not an arrest. It's not an arrest, but it is enough to keep her from being able to get away from them. And this is the thin line that cops walk between arresting and not arresting someone. Are you under arrest if you're driving home with 2 cops following you? Do you feel free to drive away? Because under this theory that she was never under arrest, what they're saying is that if she had not gone home, but she just drove anywhere else on earth, that they wouldn't be able to do anything about it because she wasn't under arrest. That's what they're saying. The measure of whether or not you're under arrest is whether or not a reasonable person under the exact same circumstances would feel free to leave. The police, The Department of Homeland Security in this case says that the convicted felon whose husband they just arrested, when they got 2 male officers showing up at her work, offered to drive her in their police car, but instead allowed her to get into her own car only if she puts her purse in the back, and followed her home and then searched her house. They said she wasn't under arrest. She was free to go. Remember that. She was free to leave at any point. And she should have felt that way. That's what DHS is saying. Again, had she run, do you think they would have tackled her and cuffed her? Yes, of course they would have. Because they're lying. They're lying in the argument. They're lying on the stand. Cops lie in court all the time, and it's infuriating because there's no argument against it. Oh, of course they would have arrested her. Of course, had she gone anywhere else. Landoname says, how much do I have to pay you to have Dick message me? I swear, get him in contact. We have to know if he eats beehole. What's your price, Nick? I'll send him a message, buddy. Maybe, I'm sure he'd want you to just call into the show. I don't know. I'll ask him. Okay. So at no point was Miss Guidry under arrest. Sure. The conversation was cordial rather than coercive. Right. Just going to shoot your dogs and remind you that you got a kid that you won't be able to take care of from prison, you scumbag. And Miss Guidry showed a high level of cooperation by leading the officers to her home, securing the dogs and revealing the locations of at least 3 guns. Yeah, that'd be great. It's so nice of her to do that. I'm sure she didn't feel any pressure to do so at all. Further, there's no requirement that she be informed of her right to refuse consent. That needs to be changed, by the way. People do need to know that they have a right to refuse consent. Besides, her prior conviction shows her familiarity with the criminal justice system and awareness of her rights. That's right. Go ask your average felon about the awareness of their rights and have them articulate clearly their rights to you. Especially if they were convicted when their rights were violated before and they pled guilty. Right? It's circular. This argument is circular. Well, got convicted before, so obviously knows all of the things that would keep her from being convicted a second time. That's not actually how it works. Okay. There's no suggestion posits the government that Miss Guidry is uneducated, is not fluent in English, or cannot read. And although Miss Guidry knew incriminating evidence existed at her home, that factor is not dispositive. According to the government, the totality of the circumstances demonstrates that Miss Guidry freely gave her consent, which is understood or underscored by the fact that 5 days after the initial search, she gave consent to search the home a second time, which the defendant does not challenge. Law and analysis. Warrantless searches are presumptively unreasonable under the 4th and 14th Amendments, absent an exception, such as when conducted pursuant to consent. That's Schenkloth versus Bustamante. They could have found a much easier case than Schenkloth versus Bustamante. The government bears the burden of proving consent by a preponderance of the evidence. Hold on just a second, guys. Sorry, I got a moderator talking to me. Government bears the burden of proving consent by a preponderance of the evidence. See U.S. v. Guerrero Barajas. Consent is valid when it is given by a person with actual or apparent authority over the premises sought to be searched. Illinois versus Rodriguez. Consent given by a third person is valid when third person possesses, quote, common authority, that is, quote, mutual use of property by persons generally having joint access or control for most purposes. So there you go. After determining that a person with authority gave consent, the court must determine whether consent was voluntary. To do so, courts in the Fifth Circuit consider 6 factors. 1, the voluntariness of the defendant's or third party's custodial status, the presence of coercive police procedures, the extent and level of the defendant's cooperation with the police, the defendant's awareness of his right to refuse consent, the defendant's education and intelligence, and the defendant's belief that no incriminating evidence will be found. It'll be interesting. It'll be absolutely shockingly interesting to find out how the court balances this 6-part test when they violate like 4 of them right out the gates. That's U.S. v. Jensen. While all 6 factors are relevant, no one factor is dispositive. Instead, the court examines every factor in the totality of the circumstances. The critical issue is whether the defendant or third party's will was overborne. Consent may not be, quote, the product of duress or coercion, express or implied, or the mere acquiescence to a claim of lawful authority. Rather, the government has the burden of proving that the consent was, in fact, freely and voluntarily given. In this case, Guidry does not dispute that Ms. Guidry had authority to give consent to the search. He should have. He should have disputed that, but principally argues that her consent was involuntary. Guidry contends that Ms. Guidry's will was overborne considering the totality of the circumstances, including the officer's alleged misrepresentations and threats. Totality of the circumstances, however, does not show that Ms. Guidry's will was overborne, but instead demonstrates that Ms. Guidry's consent was, in fact, freely and voluntarily given. I don't know how the court gets there. I honestly have no idea what sort of dark magic has to be performed to get to that mental state. When analyzing the first factor, courts generally consider whether a reasonable person would not feel free to leave. The lower standard associated with any seizure rather than the higher standard of custody, which is a degree of restraint associated with a formal arrest. That's compare Mendenhall, defining seizure for purposes of the Fourth Amendment to mean when, by means of physical force or show of authority, a person's freedom of movement is restrained, with Stansbury versus California, defining custody for purposes of Miranda as whether there was a formal arrest or restraint on freedom of movement of the degree associated with the formal arrest. Here, the officers approach Miss Guidry at her place of work. Merely being questioned by law enforcement in one's place of work does not transform the encounter into a seizure. Wait, there's a footnote. Where was this footnote? Okay, so this is, they don't dispute that she had the authority to give consent. The court notes that the officers had a reasonable belief that Miss Guidry, who resided in the same household with her husband, the defendant, albeit in separate bedrooms, had common authority over the premises to be searched. That's U.S. v. Shelton. A estranged wife had common authority over home where husband had not taken steps to prevent her access to the home, and he shared information with her relating to his illegal activities. After all, Miss Guidry testified she had access to her husband's bedroom because her clothes were kept in a closet in that bedroom. Well, there you go. There you go. Okay. Here, the officers approach Miss Guidry at her place of work. Merely being questioned by law enforcement in one's place of work does not transform the encounter into a seizure. Quote, unless the circumstances of the encounter are so intimidating as to demonstrate that a reasonable person would not have believed he was free to leave if he had not responded, one cannot say that the questioning resulted in a detention under the Fourth Amendment. But if the person refuses to answer and the police take additional steps to obtain an answer, the Fourth Amendment imposes some minimal level of objective justification to validate the detention or seizure. Remember, guys, you're free to leave your work all the time, right? Because cops are asking you questions, and the only way to get away from them is to leave your place of employment. Most convicted felons are probably in jobs where they have like a nice salaried position. They're exempt from their hourly wages. They can take away from their responsibilities and go do anything else that they want and come back and make up the time at a later date. Like that's where most convicted felons end up, right? Especially ones that are preppers who stockpile guns and ammunitions and are sovereign citizens. Like that's how the typical convicted felon turns out. But they're free to leave. Although Miss Guidry testified that her business was not open to the public, there's no evidence or suggestion that she was unable to end the conversation. If she didn't feel like she was able to end the conversation, why would she try? And while Guidry posits that, as a woman, in the face of 2 male police officers who had just been informed that her husband had been arrested, Miss Guidry would not have felt free to leave. The Fifth Circuit has, quote, held consent to be voluntary even in the face of greater shows of force than 7 officers, some in uniform and none with weapons drawn or displaying force beyond their presence in numbers. Smith testified that, though in uniform, neither he nor Mailer drew their weapons. The agent's mere presence at Miss Guidry's business did not cause her to be seized. Berserker Bauer says, hey, Clay needs your attention on something. I'll give my opinion. Buying feet pics, can you please change your name back, buddy? Just so that, like, because you know the problem with it. It's not us, it's YouTube. No one here cares about the name. YouTube cares a lot about the name. So please just change it back. That'd be great. Thanks. Guidry next argues that Ms. Guidry was not free to leave because her purse was placed in the trunk of her car prior to leaving her business. Law enforcement's retention of a person's identification for an unreasonable time may amount to a seizure under the Fourth Amendment. When law enforcement retains identification beyond a reasonable time for review, a detainee would likely not feel free to leave without it, and retaining identification suggests coercion. While Miss Guidry did not have immediate access to her purse when she drove to her home, she obviously had the keys to her vehicle and possession of her identification in her purse during the drive. The fact that the officers followed Miss Guidry to her home by car does not alter the fact that Miss Guidry exercised freedom of movement. Allowing officers to follow as one drives one's own car does not restrict one's movement by a show of authority. Again, what? What on earth? Who has ever been followed by a cop? Even one that, like, you just think is following you, but they maybe are going the same direction and not actually following you? You don't feel free to do anything. You think at any moment they're going to turn on those lights after they decide you are guilty of something. You got a tail light out or whatever. Like, you don't know about it, but they're going to turn on those. They're going to turn on the cherries and you're going to have to pull over. You certainly don't feel free when you've got 2 cops knowingly following you. Absolutely. Absolutely ridiculous. No, I don't want him booted. I don't want him booted. I don't want anyone booted from the channel, just so you know. Like, that's not my goal. But I would hope that he doesn't, that he can understand the YouTube problem with the name. But anyway. As to the second factor, the police's tactics were not wholly coercive. Oh, wait. Okay. Does not restrict one's movement by show of authority. Thus, the court finds that when Miss Guidry gave both oral and written consent to search the home, she was not in custody for purposes of first and sixth voluntariness factors, but instead chose to cooperate in the presence of police. I want you all to remember this, because if this ever happens to you, if you're ever in any situation like this, you have to know that you have to you have to be the guy to positively assert your rights. According to the courts, you have to assert your right to remain silent by speaking. You must say, I am exercising my right to silence. You must do that. You can't just remain silent. That is not an exercise of your right to remain silent. You must affirmatively assert it. You must state, if the cops are there and you feel intimidated, you say, am I being detained? Actually, you say, here's what you really say. Don't say, am I being detained? I feel like I'm being detained. I do not want to have this conversation with you. No, you do not have my consent. I will not answer further questions without an attorney present. Please leave. Go away. Especially if your business isn't open to the public. Please leave. I'm revoking your license to be on this property. Please go. All of these things have to be positively asserted because the courts don't respect our rights. They really don't. All right. Okay. As to the second factor, not wholly coercive. Guidry offers that the officers threaten Miss Guidry with the arrest and destruction of her property. However, this is an exaggerated misconstruction of the 8-minute recorded exchange between Miss Guidry and police. Instead, the court finds that the police officers never threatened Miss Guidry with arrest, nor made false promises of leniency to secure her cooperation. The court finds credible the officers' testimony that they had no intention of arresting Miss Guidry. This is supported by Marlar's explicit statement that he could not promise that she would not be arrested. The sincerity of Smith's tone in the audio recording in relating to Miss Guidry that she was not the subject of their investigation, and his subsequent testimony to that effect at the hearing. Further, at no point in the encounter did either the officers or Miss Guidry raise their voices. Instead, the exchanges were cordial and cooperative, indicating a lack of coercion. Because felons, of course, know that raising your voice with cops is exactly the proper way to deal with things. Oh my goodness. Let's see. Indicating a lack of coercion. So if the cops aren't yelling at you, they're not coercing you. Just so you know that. What am I going to drink? What do we got here? I've got just a tiny bit of this Hennessy White left. I'm going to polish off this bottle. Hamilton Burger, why am I fighting you? Okay. Okay. There we go. A little bit of cognac to finish off the day. I need to get some more cognac. I like this stuff. All right. Let's move on. In like fashion, the court finds that the officers not only never threatened to destroy Miss Guidry's property or to shoot her dogs, but took pains. Listen, oh my God. Took pains to reassure her that they would not do so. No, they didn't. They said, look, we would hate to have to execute that search warrant without your consent. Chop down your fence, battering ram the door, and maybe shoot a dog on the way in. They literally threatened to do it. They literally said, if you don't help us, this is what the likely outcome will be. No, that's them taking pains by coercing her into giving consent to do so. Oh my. Contempt of cop is a capital offense. It is not. It is what you can say to cops. Fight me. Oh, yes. I would not tell a cop to fight you. Don't do that. Don't do that. I don't have an opinion on absinthe. I've never had it. All right, here we go. So they never threatened to destroy or shoot her dogs. They took pains to reassure that they would not do so. Both the officers' words and their tone evince reassurance about these matters, as opposed to threats of harm. Moreover, informing a person of the consequences of refusing consent is not a threat if such consequences are merely the legal ramifications of a person's actions. Agent Smith testified that obtaining consent to search was the smoothest way to proceed, avoiding any risk of harm to Miss Guidry's property or her dogs. If the police were required to enter the property with a search warrant, Agent Smith testified he had probable cause to obtain a search warrant for firearms in the home. He testified so. It must be true. indicating that in his 24 years of police experience, sovereign citizens typically stockpile weapons to prepare for doomsday survival. That's not evidence. That's not even close to probable cause. Other people do this thing that have the same label as you. That means you do it. So is that probable cause to search black people for marijuana? Because you've heard that black people have marijuana, right? Other black people have marijuana. That's probable cause to search white people for white collar crimes. How do you search white people for financial fraud? What do you do? What, are you kidding me? Whomstead says, YouTuber law is taking on Patreon with FTC. Please help. Yes, I addressed this earlier. You weren't on the stream yet, apparently, which is fine. I will help in any way I can. But, you know, I'm not going to barge in on his case. If he wants my help, I've indicated to him on Twitter that I'd be happy to lend assistance where I can. Whatever, you know, if he contacts me, I'll help him however I can. That said. Upon arrest earlier that day, Guidry professed himself to be a sovereign citizen. Prior investigation indicated that community members had said that Guidry had bragged about owning firearms. Well, there you go. Community members said so. And officers had surveilled the home and observed it to be fortified with a fenced perimeter, several dogs, and unusual storm shutters. You know what some people do when you can't own a firearm to defend your home is you buy a dog that can defend your home. Some people do that. It's weird. It's weird. It's almost like when you take away one person's means of self-defense through a legal process, they find a legal way for them to defend themselves. So the ownership of dogs, just so you guys know, the ownership of dogs is one of the indicating factors for illegal gun ownership, according to Homeland Security. That's how honest they are. Darking D says, hey, Rackets, just out of curiosity, would you be willing to fund the purchase of a bulldozer and hundreds of tons of steel and concrete? Only if I get to drive it, buddy. Only if I get to drive it. We could crowdfund a Killdozer 2.0. That'd be great. Taken together, these facts could amount to a fair probability that weapons would be found in the home. That's United States versus Sokolow. Given that probable cause to obtain a search warrant existed, it just did now. Now, mind you, this judge is looking at this where they did find guns in the home. Do you think he was not going to find probable cause? Of course he was. Of course he was. And then train the dog to own guns. Probable cause to obtain a search warrant existed. Mind you, there's no probable cause analysis done by this court by a neutral magistrate without knowing whether or not there are guns in the property. That never happened. It never happened. But this judge is saying that it did exist, even though that process literally could not possibly happen. All right. The officers could have broken down the door and shot the dogs in executing the search warrant if necessary to gain access or protect those involved. Sure, they could have, of course. Thus, the supposed threats to Miss Guidry's property or dogs did not constitute duress or coercion because such actions would be legal courses of action if required to execute a search safely. There you go. There you go. Might have to shoot your husband too. Or your son or your daughter. Anybody. Might have to shoot your friends. Might have to burn your house down. Might happen that way. We don't know. We don't know. Might have to flashbang the inside. Might have to rip up all your clothes and search them for cocaine. I mean, if that's the search warrant, might just have to take you into custody and put you in jail forever. That's a legal reaction. A legal reaction to having to execute the search warrant. So that's not a threat. Guidry asserts that the officers forced Miss Guidry to cooperate by suggesting that her child would be left unsupported. This, too, is an exaggeration of the officers' words. I mean, they only said exactly that. They only said exactly that. By the way, did my audio just spike? I'm trying to get an indication on my feedback that I get when the audio spikes. And I am working on a new mic. I know I keep saying that, but I don't want to just go out and buy another junk mic. While it is true that in some extreme circumstances, praying against a person's paternal instincts could overbear a person's will, the defendant has articulated no such circumstance here. Compare Lynham versus Illinois. Coercion where police officers promised leniency from a 10-year sentence to a single mother of 2 infants who had no previous experience with the criminal law. And United States versus Tingle. Coercion where officers alluded to leniency from maximum penalties totaling 40 years to a mother of a 2-year-old. I mean, they didn't allude to leniency at all. Not anywhere. Not only did they specifically said it. Compare it with United States versus Casby. No coercion where officers implied child had already lost one parent and wouldn't lose another one if person confessed, distinguishing extreme circumstances in Lyman and Tingle. So because they told them about the length of the sentences, that's what makes it suddenly coercive. Ryan English says, it's awesome that nice car you got here. Shame if something happened to it is not a threat. New business opportunity, MAGA. I have a Yeti Blue mic. Buying feet pics. And I get sporadic complaints of audio spiking to horrific levels. And I hate that occasionally it will do that. I'm not able to see it happen live. And so I don't know what's causing it. I don't know if like my head moving or something, or me moving, or me getting here or something is causing it to spike. So I'm trying to get a grip on that. But I will be getting a better mic. And buying feet pics, you can just, I know you know about this stuff, so send me some. You've sent me some stuff in Discord before. Do it again, please. Okay. So here we go. At one point during the exchange, Marler told Miss Guidry that we don't want to involve you because you still got work and you have a child to take care of. This is the full extent of the reference to Miss Guidry's daughter. In context, the courts find that the words were intended to reassure, not threaten or intimidate. Oh my gosh. Yeah, exactly. That's what they were doing. That's why the cops brought up that daughter. Again, this conclusion is reinforced by the tone in which they were conveyed. Look, you got that daughter to take care of. We know. We know. Believe me, we know. Moreover, unlike the defendant in Lynham, Miss Guidry had at least some experience with the criminal justice system as a convicted felon, so had some ability to evaluate the officer's words. Guys, the judge literally just said, this chick is a convicted felon, should know better that officers are lying to her. That's what he just said. That's the funniest thing he could have possibly written. Oh my gosh. Holy cats. Is there a footnote observing the soothing effect of the sound of cocking the hammer of the officer's firearm? No. The footnote that does exist is only a reference to the defendant's documents. Dear Lord. But even if Marler's remarks were less benign, they, like the comments at issue in Casby, did not rise to the level of coercion. It'd just be a shame if you weren't there to take care of your daughter. Cops suck. I'm sorry, they do. Oh my gosh. When they act like this, they're the worst people on earth. Any government agent who threatens to leverage someone's child against them to get what they want can go straight to hell. You can go straight to hell. I mean, you better know that person is beating the child. Other than that, like if you have no evidence of endangerment for that child, you just think, well, it'd just be a shame if you got arrested and that kid, your nice daughter there, would have to go into the foster system or live with a relative and not know their mom. You can die in a fire for all I care. You will get no respect from me ever. I was raised for 30 years to respect cops, right? We all were raised to respect cops. Yeah, no thank you. No thank you. You leverage someone's children against them, you can get shot all you want. I mean, that's you're disgusting. Disgusting people. Whew. All right. Sorry for that tangent. Like again, here's the problem. I know cops. I know good cops. And the idea that those good guys might ever do this makes me want to vomit. And I pray that they never, ever do that. It's, that would be, you know, when you know someone of good character and they do something so disappointing and disgusting that you can't look at them. I mean, that's what that would do to me. So I have to assume that these are bad cops because the good cops that I know, I can't imagine that they would do this. And I'm going to keep that nice little fiction in my head and hope that it's a real thing. Because it would, oh gosh, that would destroy. If I ever found out about that, I could never talk to them again. Darking D says, moral of the story, assume cops are always lying. They could tell you the sky is blue and rain falls from the sky. They're lying, period. Never trust the effing pigs because if you do, they'll F you. Which is, I mean, that's the only way to deal with cops. Even if you don't actually believe this, that's the mentality you should take when talking to them. That's very, very good advice. Bagel Goose says, in Minecraft. Asterisk in Minecraft. Yeah, exactly. Keck7 goes, says, I bet Legal Eagle would defend cops over citizens and their rights. You know, maybe he would. I don't know. I can't stomach enough time of his videos to find out. Guidry makes much of the government's alleged misrepresentation that Guidry confessed to everything. Quote, any misrepresentation by the government is a factor to be considered in evaluating the circumstances. That's citing Davis. Consent induced by an officer's misrepresentation is ineffective. I mean, is it? Is it ineffective? Because it's always done. It's always done. That's citing Cavett. The mere failure of the officer to give an encyclopedic catalog of everything they might be interested in does not alone render the consent to search involuntary. The dispositive question is whether the government agent was found to have intentionally deceived the defendant by making false representations in order to induce consent. Oh, well, that's the dispositive question. So did they lie to her about what her husband said to induce consent? The answer to that is clearly and objectively yes. Yes, of course they did. Of course they would come in and say, he told us everything. He was just arrested. He told us everything. We already know. Of course they misrepresented it to get consent. So if that's the dispositive question, it should be dispositive. Let's see the judge's reasoning. In his testimony at the hearing, Smith admitted that Marler lied to Ms. Guidry when Marler stated, we talked to him and we know what's in there. Prepping. He told us everything. On this record, the court cannot say that the supposed fabrication played no part in Ms. Guidry's consent. Yet, the totality of the circumstances on the record as a whole does not indicate that Ms. Guidry's consent was induced or that her will was overborne by this ambiguous misrepresentation. It's literally the first thing that they said. It's the first thing. They come in. I kind of expected you guys. We just arrested your husband. He told us everything. Everything after that they used to then support. It all comes after the coercion. Oh my gosh. YouTube is gay says, what does dispositive mean? Dispositive means it's the opposite of positive. If it's dispositive, it is a disproof of a thing. A dispositive would be to make the thing that is to not. So the dispositive question in whether or not she was coerced, if they lied and that overbore her will because of the misrepresentation, then it would be dispositive of the idea that she was not coerced. I hope that makes sense. It's kind of a weird thing, but it just means to make something false. Okay. Let's see. Citing U.S. v. Andrews. Finding valid consent despite officers' misrepresentation of purpose to arrest defendant for illegal possession of a firearm when defendant, quote, showed no hesitancy in answering police questions or in otherwise cooperating with police. So that apparently cooperating with police works against you. Just remember that. Cooperating with the police will be used against you. So will not cooperating with the police. By the way, if you don't cooperate or if you do, that's a factor against you. And was not even under arrest and indeed had an hour in his own vehicle to reconsider his consent while the cops just waited right behind it, probably. Right? U.S. v. Andrews? I don't know what that case is about, but I can only imagine that he just had an hour in his own vehicle with the cops standing there or sitting in his squad car right behind him, waiting for him to reevaluate his question. Like, the way the courts handle this is absurd. It's absurd. Their reasonable person is like Mensa level, Mensa levels of intelligence and undercover brother levels of cool in all circumstances. They're never intimidated or coerced by anything. They're always objective. They have no adrenaline. Those adrenaline glands thrown right out of the reasonable person. They have no fight or flight response. There's no tension or anxiety. They're perfectly calm and rationally assessing every single thing that happens while cops are questioning them, and they know that if they answer wrong, they go to prison, maybe forever. Who knows, right? Dear God. Okay. Here we go. That case was abrogated on other grounds. U.S. versus Grobstein. Finding valid consent where DEA officer misrepresented himself as a police officer who made, quote, repeated requests for consent to search through the vague and ambiguous description of his purpose as security. Look, we just need to search your property for security. I'm a DEA officer, so I'm specifically looking to find drugs in your house. But I'm not actually I'm just a police officer, and I'm just looking to search your property for your security. That's it. That's fine. It's not misrepresentative at all. What are you guys talking about? Marler's use of the term everything is vague and ambiguous. Guidry had told the officers about his political and religious beliefs, which included prepping. But he had not told them about any firearms. Did Marler's reference to what's in there mean to include the firearms or something other than firearms, like the dogs? Like, okay. Listen, lady. He told us everything. We know what's in there. Does that mean the illegal thing or the not illegal thing, the not illegal thing or the not illegal thing? Actually, judge, cuckface, it means everything. Everything. He told them everything according to them, which is a lie because he didn't tell them everything. He only told them a little tiny bit. But because she knows there are guns in there and that they're felons and can't own those guns, when they say he told us everything, it's probably not the 10 months of dried food that he's talking about. It's probably not the perfectly legal to own dogs and puppies that he's talking about. It's probably not anything other than the unlawful firearms that she's concerned about. You lying sack of trash. What on earth? Did Marler's reference to what's in there mean to include the firearms or something other than the firearms, like the dogs, the provisions, or the security features of the home? Presumably, in agreeing at the hearing with defense counsel that Marler's statement was a lie, Smith believed the reference to encompass firearms. Of course he did. Of course they meant the firearms. Only the sole reason for Smith's search, only the fact that he's not accused of any other crime than owning firearms as a felon, and that's what he testified to knowing about, and that's what he used in his probable cause statement. Only all of that. Of course he meant the firearms. Of course they were lying about it, and of course it was to induce a coerced consent to search. Of course they were. Smith believed the reference to encompass firearms, but a single vague reference, even if a lie, is not determinative of the voluntariness calculus. Quote, particularly because physical coercion by police is only one factor to be considered in the totality of the circumstances, we should approach psychological coercion the same way. U.S. versus Spivey. In that case, says deception by law enforcement as to identify identity of officer and nature of investigation did not render a suspect's consent to search a home involuntary because it was relatively minor, creating little, if any, coercion. Importantly, the officers here did not brandish their weapons. Again, like if a cop is drawing a weapon on you, that's a whole nother level. But coercion happens long before a weapon is drawn. You can coerce a cop, by the way, without drawing a weapon. I don't know if you know this, but if you were to try and use magic words to get a cop to do your bidding without using a weapon, like say, you know what, officer, I know you got a wife and it'd be a shame if you didn't go home today. Well, what did you mean? Did you mean you were going to shoot the cop? Or maybe did you mean that the cop was going to arrest you and spend all night in the booking room and interrogation doing his job? I mean, maybe that's what you meant, right? That would be the legal consequences of the cop's actions. You weren't threatening his wife by saying, you know, he's got a wife and it'd be a shame if you didn't go home tonight. It would just be a shame, literally, if the cop didn't go home that night and had to wait until the morning. That's what you're saying. Oh my gosh. Did not brandish their weapons, use handcuffs, or make threats to use violence or force, which shows an absence of coercive police procedures. Nor did the officers conceal the nature of their criminal investigation. Rather, they honestly informed Miss Guidry that her husband had been arrested on a weapons charge. Thus, the misrepresentation of Guidry's confession, such as it was, is the only tactic that can be characterized as coercive to any degree. Overall, the encounter was untainted by coercion. Actually, that one factor could be coercive enough. It really could, and it definitely was. Oh, and not to mention that it was first and colored all of the other ones that you analyzed in reverse order. That was nice strategy, Judge. As to the third factor, Miss Guidry's cooperation was extensive. At her place of employment, Miss Guidry answered the officers' questions in a civil tone. Don't be civil, I guess. Made plans to leave work for the day to accompany the officers in the search. She definitely felt like she had a choice, I'm sure. And permitted the officers to use the restroom. Well, that was nice. That was nice. So that, by letting them pee, by extending the common courtesy of, you're at my place of work and you need to use the bathroom. Don't ever let cops use the bathroom. Legal advice. Never let a police officer use any bathroom ever. Ever. Just don't do it. Because it's going to be used against you. I mean, sure, if you don't let them use the bathroom, what they're going to say is that they knew that there was something wrong the second you didn't let them use the bathroom. Sure, that'll be used against you, but so will letting them use the bathroom. She drove her car approximately 20 minutes from work to her home, rather than ride in the squad car with them. That was her option, was ride in a cop car or drive herself. She chose drive herself. Oh, man. Who would dare think to drive themselves rather than ride in the back of a cop car at your work? Yeah. You know what looks good for a convicted felon at work is to have the police show up, question you for a while, and then you leave by getting into the back of their cruiser. That looks great. I'm sure your boss isn't firing you the next morning. That's fine. At the home, she signed the consent to search form. Guidry's argument that Miss Guidry never gave written consent prior to the search is without merit, even though the officers couldn't remember when it was actually signed. Officer Holly's recollection that Miss Guidry signed the consent form prior to the search is more reliable than Miss Guidry's recollection, given that Holly recorded the time he administered the form and at the time that the search began, and that Holly was in a less stressful situation than Miss Guidry. Wait a minute! I thought this whole thing was not stressful. It was perfectly cordial. There's no coercion or duress. What are you talking about, Judge? How can the cop who's walking into the dangerous home of a prepper with violent dogs and guns, convicted felon with automatic weapons, he's in a less stressful environment than the perfectly non-coerced, no duress person who's rationally making all these decisions of her own free will after the police just freely showed up at her office? This is the criminal justice system, guys. This is it. The sad thing is, this is not the exception. This is not the exception. This case is the rule. This is how it works. If you want to know why poor people plead guilty to crimes they didn't commit, this is what you're up against. In this case, of course, we know that these people were guilty of owning firearms as felons. We know that, right? Like, they own the firearms. They are felons. That is a federal crime. But the entire process, the process that is designed to keep the innocent safe, in this case, being used improperly against the guilty, would also be used improperly against the innocent. Trust me, it is all the time. Okay. All right. Okay, so the cop's recollection is more reliable than the felon who owned guns. Darking D says, seriously, Killdozer, just cruise around the country leveling courthouses and PDs. The National Guard will probably bring in anti-take weapons eventually, but hell, it'll be worth it. You wouldn't get to the second town. You might not get to the first one. All right. Moreover, Miss Guidry demonstrated her continued implied consent by opening the gate, securing the dogs, and showing the police the location of the guns. Siren Jag says, masked you. So that's this little face that's on my face. It says, are you my new mommy? Apparently. Apparently. That's what this lady's daughter would have to face, right? If you don't let us in, it'd be a shame for you to be arrested and have to have your daughter raised by some sort of Yeti. Holly testified that her demeanor was cordial and helpful. Probably because she doesn't want to be shot. I don't know if you know this, cops, but so I talk a lot about shooting black people. I'm pretty sure these are white people, Guidry. I don't know that. I'm assuming that they're white people. Preppers and sovereign citizens. I don't know. Maybe I'm stereotyping. Cops shoot more white people than black people, right? Like I talk about the cops shooting black people because I do think the black populace's legal experiences with law enforcement is wholly different from whites. But yes, the actual statistic is that more white people get shot by cops than black people. You think you want to take a non-cordial tone as a prepper with automatic weapons in your house that the cop's looking for? You want to take a non-cordial tone with a cop? I don't. Yes, sir. No, sir. Please and thank you. Would you like me to wipe that for you, sir? Right? Like, that's probably what she said after they went to the bathroom because she's afraid of getting shot. All right. I gotta take a second because this stuff burns me up. Okay. When the search commenced, Miss Guidry led the officers straight to the bedroom, moving the mattress to uncover the gun so quickly that the officers had to instruct her not to touch the gun. I mean, she just did it right away. But she's calm. Remember that. Remember that this lady who led them right to a federal felony for her led her right to, because her having access to that gun and being able to have access to her husband's room and knowing where an automatic weapon is a serious federal felony. Probably 2 to 3 to 4 if it's an automatic weapon, as they state. Felonies for her. She walks right to it and throws up and practically throws the mattress out, right? Herculean toss of that mattress. So fast that they had to say, whoa, 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 don't touch that gun. I bet their hands are on their firearms then, right? They didn't brandish them. No guns were drawn in the making of this case. They had to tell her not to. Calm people who are cordial and perfectly calm and not under any duress, they normally run down and admit to a felony as fast as possible. That's the normal thing that they do. Okay. And she described and showed the officers location of at least some of the other guns that were seized. This factor weighs significantly in favor of voluntariness. Fourth, even if true that the officers failed to inform Miss Guidry of her right to refuse consent is not dispositive of the constitutionality of the search. Rather, the failure to inform a person of one's rights is but one factor to be considered in evaluating voluntariness. Here, the officers did not inform Miss Guidry of her right to refuse consent at the time she gave oral consent in line with what Agent Smith testified as their standard operating procedure. Nevertheless, Miss Guidry was a convicted felon who was not unfamiliar with the criminal justice system. That's United States versus Galbraith. Any weight given to officers' failure to inform felon of her right to withhold consent offset by prior experience with constitutional rights in a criminal setting. So because she was already arrested, tried, and convicted, or arrested and pled guilty and convicted, she should know all of her rights. She's a constitutional law scholar at this point. Never mind the fact that constitutional lawyers, honestly, probably couldn't tell you an accurate summation of every single right that you have. Like, they probably couldn't do it. But this convicted felon definitely can. Philip Stahl says, I'm always polite and white, but I never cooperate. Yeah, don't cooperate. Guys, I don't cooperate. I'll tell you a story in a little bit. Okay. Okay. Though Miss Guidry testified that her prior conviction and experience did not provide her with a complete understanding of her rights. So when she testifies under oath to the court, she's like, actually, I don't really understand my rights. The court says, no, but you should, though, because you're a criminal, so you should know. There you go. The judge knows better than the person, yet again. However, Miss Guidry did sign the consent to search form before the search began, and that form specifically recites that, quote, I have been informed by the above-named officer, Holy, that I may refuse to consent to any search and that I may revoke my consent to search at any time. Try it. Try revoking your consent to search mid-search. Go for that one. See how that pans out. Good luck. Holy also testified he informed Ms. Guidry of her right to withdraw consent at any time. On balance, this factor weighs somewhat in favor of voluntariness as to the oral consent, but certainly as to the written consent. Because when the cops are about to search your home and they say, oh yeah, by the way, you already consented to this, but we need you to sign this form, what they definitely do, they definitely go through and read each factor to you and make sure you understand those rights. That's what their mind is on right then. They don't say, yeah, we just need you to sign this. Just procedure. You know, you went ahead and you already consented. So we could search your form now. Because that's what the court said, by the way, that even if this form was signed afterwards, remember that. The court said even if the form was signed afterwards as testified by the person who signed it, even if that's what happened, she gave oral consent before. Now it matters that the form was signed because now it matters that it's written on there that they have a right to refuse consent. Mind you, the lady testified, I didn't sign that form prior to the search. And the judge said, too bad she gave oral consent. Too bad she gave oral. Sounds like the judge hates women. YouTube is gay? Probably not. Probably not. Good luck revoking your consent. Good luck doing that. As to the fifth factor, the government contends that no evidence exists to suggest that Miss Guidry was uneducated or unable to read or understand English. Here we go. She's perfectly educated. She testified that she had an 11th grade education and received her GED, practically a scholar. She's employed in a security business. In her testimony, Miss Guidry displayed no difficulty in understanding and responding intelligently to the questions of counsel. This factor weighs in favor of voluntariness. That's right. Absolutely. She got that GED. She's good. Sixth and finally, with respect to the test for voluntariness of her consent to search, Miss Guidry was indeed aware that incriminating evidence would be found in the home. Knowledge that contraband will be found pursuant to a search tends to show that consent is involuntary. However, weighing this factor in favor of involuntariness is not dispositive. Notice all of the things that are in her favor that are just not dispositive on their own, but 3 of the 6 factors he has just stated are not dispositive. And the other ones he just walked around. We'll talk about that in a minute. United States versus Arias Robles. Affirming holding that defendant's wife voluntarily consented where she, quote, was aware that incriminating evidence was at the house because she pointed heroin out herself. In sum, the totality of the circumstances does not establish that Ms. Guidry's will was overborne in consenting to the search of her home. Even though she testified to it, even though her husband testified to it, even though the judge flat out ignores all of the testimony and evidence and makes up a whole bunch of stuff in the contrary, that's totality of the circumstances. While the officers may have misrepresented the nature of Guidry's confession, the rest of their statements were truthful and reassuring. Importantly, the fact that Ms. Guidry departed work and drove in her own car for 20 minutes to her home demonstrates a high level of cooperation and evinces an act of free will. Because most people would just drive 20 minutes to their home in the middle of the day freely. Not because there are 2 officers saying that they've arrested their husband and just don't want to take their kids or shoot their dogs. That's why. Because they wanted to. Her free will was to go home in the middle of the workday and make arrangements that she wouldn't return to work. That was her free will. Remember that. For she had reasonable opportunity to change her mind. And I'm sure, again, with cops following her home, she thought she could go anywhere other than her home. Once at the home, Officer Hawley again asked Miss Guidry for consent to search before any officers entered the home. And Miss Guidry freely provided written consent, even though she says she didn't. I mean, there's just that. Miss Guidry cooperated further by identifying the location of certain guns in the home. Furthermore, although tangential to the consent on March 2nd, Miss Guidry's second unchallenged consent to search the home on March 7th tends to confirm that her initial consent was freely given. Because after the cops came and took all the illegal stuff in the first one, her second consent retroactively reinforces the first consent. Her second consent, after they've already found felony materials in her home and withdrawn them, her second consent then reinforces that by going back in time. It's a Marty McFly consent because that's how that works. Tends to confirm that her initial consent was freely given. Thus, the totality of the circumstances, even though the circumstances aren't actually the circumstances, indicate that Ms. Guidry's voluntary consented to the search. Conclusion: for the foregoing reasons, because the court finds that Ms. Guidry's consent to search The Guidry home was valid, authorized, and voluntary. Motion to suppress is denied. Boom. Done. Done. That's the document. There you go. Nothing to see here. Move right along. This is how it works, guys. This is how it works. This is your criminal justice system. That's your Fourth Amendment protection. And if you want to know why all of this is okay, why all of this is okay to the court, why the court reasoned backwards through this stuff, because it literally did, if you noticed. In its argument, it reasons backwards in time through consent, and it reasons backwards in time through the statements made by the police. Getting to that first statement that matters, last. If you want to know why they do that, it's because they found the illegal stuff. Judge knows. Think of this. The judge's job is to enforce the rule of law, and the judge knows for a fact that this lady and her husband were violating the law. He absolutely knows it. He can prove it. It's easy to prove. They pulled the unlawful guns from the house. Of course he knows it. So what do you do? What do you do in a media frenzy over gun violence with some scary preppers who are unlawfully possessing 6 firearms? 6. Guys, can you imagine? Can anyone even imagine owning 6 firearms? I mean, I would love to, but I own 0. They're all gone. They all vanished. Tragically lost. With all that pressure on the judge, how can they not act this way? How can he not find, of course everything was fine. We found all the illegal stuff. We know they're guilty. If they win on this, they're not guilty. We let a dangerous person with no respect for law because they're a sovereign citizen. You think this guy respects the judge as a sovereign citizen? You think he respects the authority of the cops? He's a, what is it? A Section 4 free inhabitant, sucker. He's under the Articles of Confederation. He doesn't even recognize the value of this court. You think the judge wants to find that guy innocent? The Constitution demands protection for this lunatic. It demands it. And the court doesn't provide it. The cops don't provide it. And cops push against the Constitution constantly. Constantly. Push. They rarely step far over the line. I mean, they will. But rarely will they step far over the line. But they push the boundaries just a little bit. What my Fourth Amendment professor in law school said was this. If you really want to know good Fourth Amendment law, you really want to know how it works, talk to a cop because they're great at it. Remember that when they violate it with regularity, with absolute regularity, they violate it. Then they lie about it later. Why? It's easy for them. Cops know they're not stupid. They're good at their jobs. They know when you've got drugs. They've got a profile of a drug user, and yes, you fit it. Of course you do. If you have drugs, there's certain behaviors that cops see all the time. They know it. They know this guy's got guns. People are talking about it around town. He's kind of this loony guy. He's got a bunker or whatever, some strange shutter windows, fences, and mean dogs. Of course this guy's got guns. Obviously he's got guns. He thinks the world's going to end or the U.S. is going to plunge into anarchy or whatever and his gold stash is going to be in danger. He's got guns. There's all sorts of profiles that these guys build up in their minds. They're not allowed to use them overtly, but they have them. They're not stupid. Cops are smart. Remember that cops are smart because they act stupid all the time. Why? Why do they act stupid? Because it gives them a little more power, a little more leverage, makes them right. They get promotions. It's disgusting. Cops know Fourth Amendment law and respect it 0. They respect it 0. You don't respect the law if you're pushing against the boundaries of it. You don't respect the Constitution if you're pushing against the boundaries for more power for the state. If you're a statist scumbag, you're a statist scumbag. Period, period, period. No cop who pushes past the Fourth Amendment respects the Constitution. If they do, they're lying to you just like they lie to everybody else. There are cops that do respect it. There are a lot that don't. So remember this. Remember this. If I can help you in any way without giving you actual legal advice, it's remember how cops work. Remember how courts retroactively reaffirm the cops' beliefs, especially if they find something. Guys, I know none of you are criminals. I know none of you are. But if you happen to have weed, if you happen to have cocaine, heroin, meth, if you happen to have any of these things in your house, even if they're not yours, if you happen to copyright pirate DVDs or something, you can never, ever let your guard down. You can never, ever consent to a search. If you've had one drink at a bar, one drink, even though you know you're under the legal limit, are you going to consent to that breathalyzer and field test? No. No. Why on earth would you do that? Are you going, like your buddy just got out of the car, you just dropped him off, you guys maybe had a little bit of a lit weekend, you don't have any weed, did your buddy drop any in your car? Don't consent to the search. Did the cop drop any in your car? That's the real question, right? Prove it. Prove it. That's not mine. Oh, that's what they all say, right? The cop's more credible because he's not the one with his car being searched, right? You are. Remember that line from this case. Remember all of this, because this is how it works. Like, we live in this fantasy land for most of our lives about how law enforcement works. It's this great place where there's all these rules restraining the cops. The reality is they don't follow them. They ask for forgiveness later. It's easier than asking for permission. And they're in that uniform and they have 24 years of service under their belt. All cops have served for like 15, 20 years. I've never met a rookie cop. Never one on the stand, right? They're all experts, by the way. These experts routinely screw up what they're expert at, but ignore that. Ignore that. Gojirify says, what if I have fireballs? If you have fireball whiskey, you should be arrested, frankly. Later, Hamilton Burger. NPC 79855. You can love cops all day, but I mean, I'm sorry, buddy. They don't. When you're in this system, you have to assume you have the bad one, because you don't have the good one. I promise you, you don't have the good one. Even if you have the good one, you don't have the good one. You've always got the bad cop. Treat it like that. It's for your own protection, especially if you're innocent. Especially if you're innocent. So. I've got a story for you guys. I'm trying to figure out how to tell it. So I had a client in a, real quick, Rickard. So the police and the courts come off as a form of feudal caste. So what happens when they tack on more laws so everything is illegal? I don't know, buddy. You know, it's up to Congress to decide what is legal and illegal. And then it's up to you to comply. And if you don't, well, that's a nice daughter and dog you got there. A Scanner Daffley says, Nick, what do you think about the video on YouTube where a lawyer brings a cop in to tell you not to talk to the cops? The cop tells you talking never helps. Yes, that's Rutgers University. It's a Rutgers University presentation by a lawyer and a third-year law student who is a former cop of like 20 years. Because, again, all cops have been doing this forever. And they'll tell you exactly why you don't ever talk to cops. Their job is not to help you. That's not why they're there. It's not why they're being paid. That's not their job. Their job is to find someone guilty of some crime. Period. That's it. And that could be you. Absolutely. So yeah, that's a great video. Never talk to the police. Never. You're not the guy who can. And by the way, if I got arrested today, I would have a lawyer talk for me to the cops. 100%. You're not the guy. No one's the guy. I will not answer any questions. I'm exercising my right to remain silent. I would like to have my lawyer present. Oh, remember, by the way, Louisiana, that's where this is, the Eastern District of Louisiana. Louisiana is where a black guy said to a cop, no, get me my lawyer, dog. Right? He said, get me my lawyer, dog. And the judge said he was not exercising his Sixth Amendment right to counsel because he was asking for a lawyer dog, not a lawyer, comma, dog. Not calling the cop dog is like an honorific. He was literally asking for a dog that was a lawyer. That's where we are. That's where this took place. The Sixth Amendment right to an attorney was not exercised because he asked for a lawyer dog. It's ridiculous. It's ridiculous. So that's where we are. So I had this civil case. It was a rental dispute. And it was a mess. And the long and short of it is my client's stuff was left in property of the landlord. And the landlord was being a complete jerk. Up to, by the way, lying to the court and then violating the court's order to return property and denying entry to the property to my client, who was accompanied by police per the court order that the other party drafted as an agreement. So like they agreed to this, it was their idea. And then when my client exercised those rights, they kept them out. So they kept my client's property. By the way, the cops were absolutely useless in that process. So when this person clearly stole my client's property by preventing my client access to that property for something like a month, and we called the cops multiple times to say this is felony theft. Because in Minnesota, theft or preventing someone from accessing their own property, that's theft, in excess of $1,000. This is about $12,000 worth of stuff. This is a person's entire life. That is a felony. That is a felony theft. And that is punishable by 3 to 5 years in prison. That is punishable by, any damages or whatever are reimbursed as restitution to the victim. Try and get a cop to help out in that situation. That's a civil matter. No, it stopped being a civil matter when they violated the court order that says that you can enter the home and they denied it. Oh, no, that's a civil matter. What do you want us to do? Arrest him. Well, why would we arrest him? I don't know. Theft, violation of a court order. This is what you deal with. This is what you deal with. Working with cops will dispel any illusions. A scanner daftly says, you don't want a criminal lawyer. You want a criminal lawyer. Absolutely. Gojirify says, K9 Bertson and Zaid, attorneys at law. Do you think if he said, get me my lawyer pig, they would have understood that statement? No, they would have just looked for a swine-shaped attorney. Actually, that's any attorney, I think. Okay, so on with the story. So they prevented my client from access to my client's property for about a month. And the real critical aspect of this was my client had animals, some pet lizards, right? A couple geckos, a bearded dragon. And my client really wanted those animals and feared for their safety. And, this is my client's therapy animal. Very important to my client. And I mean, I don't care that much about any animal, but too many tears were shed in my presence over these lizards. So we found out that the entire time when they said they had been caring for the animals, that they actually lied, and they returned them to a pet store that they were not purchased from. The animals did not come from the pet store, but the pet store took them, and there's a lot of circumstances around that we're not going to talk about because it's not really here nor there, or it's neither here nor there. Philip Stahl says, they were obviously asking for landweed, dog. Yeah. And Gojira says, Arnold Ziffel for the defense, Your Honor. There you go. So, so we found out where they had returned the animals. So what pet shop they returned the animals. So we went to go get them. And my client was had knowledge, had familiarity with the pet store employees. And one of the pet store employees recognized actually the bearded dragon from my client. The geckos were given to the store dead already. So these people lied when they said they were taking care of the geckos. They had let them die, and then they gave them to the pet store, and they were already dead. That was nice. The bearded dragon was still alive, and one of the employees recognized it as my client's animal and returned it to the client. Now, the interesting thing there is that the police showed up. We actually called the police at first to help us get the animals, although the police officer was completely useless in helping us get the animals. Didn't help us at all, and the one store employee was very standoffish for reasons that I don't need to talk about here. But the police officer was like, I don't even know what this is. So whatever. He was no help. He leaves. We get the animal. My client leaves with the animal. And I went to, my client left out the back to avoid issues with the front employee. It's very important to note that this was my client's animal and that store did not own it at any point. Okay. That's very, very important here. But my client left out the back with the animal, with the consent of the employee who worked for the store. And then I went to purchase, on behalf of my client, some food for the animal because all of the supplies of my client were still at this person's house, the landlord's house. So I purchased some food for the animal at the front. During that time, a cop comes in, two cops come in to the front door where I am, and they asked me if I was so-and-so. And they gave a very interesting description of my client, but it was clearly my client they were looking for. And I said, nope, because I was not so-and-so, right? I was certainly not my client. And that's it. That's all that was said. Should I have divulged more information to the police? Absolutely not. Absolutely not. There was no, I don't know why they were, I actually literally don't know why they were asking for my client. No idea. What I will tell you is this. I don't care why they were asking for my client. Not one bit do I care about that. They were completely unhelpful the entire time. They never followed up on it, despite, you know, they have my client's phone number. They have my phone number. None of that ever happened. I have no idea. But let me tell you what could have happened if I would have cooperated with the police. A lot of ridiculous shenanigans, because the other part of that case was that the landlord lied, fabricated a story about my client assaulting his wife with a deadly weapon. Literal complete fabrication. We tore it apart on the stand. We won all of this. The court recognized that it was a complete lie. Also lied about my client beating their children. Something my client never did in any category. And by the way, if you have someone living in your home who beats your children, the first thing you should do is call the police to have them arrest that person. They never did. And they lied to the court about calling the police in the other instance where my client was accused of assaulting them with a deadly weapon. They said they called the police and the police came out and didn't do anything. Interesting story about that is you can actually call the police and see if they were ever called from phone numbers, addresses, and names. Because it's almost like the cops keep record of this stuff, and the call never occurred. So why do I want to answer questions about this law to this cop who's asking about my client? I certainly don't. I certainly don't. Because I can assure you that they would have been based on lies in the first place. And the fact that there's no follow-up lends to that conclusion anyway. So, guys, don't cooperate with the police. Polite, respectful, assert your rights. Period. That's how you handle every cop encounter. Polite, respectful, assert your rights. If you get pulled over at a DUI checkpoint, check with your state, check with an attorney in your state, but you don't have to roll down your window. You don't have to do much of anything. They can stop you. They can ask you for your license. You can just say, no thanks. What'd they pull you over for? It's different if you get pulled over. But if it's a checkpoint and they're pulling everyone over, you don't have to do much of anything. And I would check with your state on that. Don't help them put you in jail, especially if you're innocent. And even if you are innocent, you can wind up in jail very, very easily. Very easily. So, Gats says, happy birthday to me. Drink Clay. Hey, what's up, Gats? NPC 79855. What if I have no alcohol at all? Should I consent to a breathalyzer? I can't give you legal advice, and that's getting dangerously close. It really depends. I mean, if you know for a fact that you're that you have no alcohol in your system, I mean, I guess it's up to you. But the legally safe answer is no. That's not the pragmatic answer, right? Like if you know you weren't speeding and a cop pulls you over or whatever and asks you how fast you're going 45 and a 60. Like, oh, I was going 45 and a 60, taking a leisurely drive. There's really no legal harm in that, but it's better to not say anything for your legal case. Like, that's the better answer. But that might be a more problematic answer in the time that you're there. Not consenting to a breathalyzer means they might want to take you in. They might want to take you in for a field test or for an intoxilizer at the station. If you refuse consent there, you might lose your license for a year, and you have to weigh that out. And that's an unjust system, by the way. But you know, whether or not you consent is highly specific to your case and your jurisdiction. So I don't want to say no, but you have to weigh all of this out. You have to weigh all of it out. And I would suggest talking to an attorney in your jurisdiction about that. Where Tiger Ray says, could she have sued the landlord for lying in court? We didn't really need to sue the landlord for lying in court because we had already gotten all of that. That was part of the lawsuit, was all the lying, and we got that taken care of. So Gojirify says, get a DUI lawyer, but not a drunk lawyer. Yeah, absolutely. Don't get a Kevin Landau. And then Marsupial Gamer says, Merry Christmas and Happy New Year, Nick. Merry Christmas and Happy New Year back to you, buddy. All right, guys. Domina Morgul says, Nick, if you take rep rights that fully respond, man, they need all the help they can get. Not lucrative, alas. I'm not sure what you mean by that. YouTube is gay. If a cop asks, is there weed in there? What should you say if there's weed in there? You should say nothing. You don't have to ever answer that question. Those are the types of questions you don't have to answer. And that's where you say, look, I'm not going to answer any of your questions. And that's why you don't answer any of their questions. Remember, generally speaking, especially if you're in a car, a cop can ask you to identify yourself. They can ask you for your insurance if you're driving in a car, and your driver's license. And you do have to identify yourself, maybe, unless you're not being detained. If a cop walks up to you and says, who are you? You can say, nobody, and walk away. Absolutely. Now, if they tell you to stop, you're being detained at that point, and everything changes. In a car, if you're driving and you're pulled over by flashing lights, you're already being detained. Yes, you're being detained in that moment, and you do have some basic information that you have to give. It's different state by state, but for the most part, generally speaking, you're talking about giving your name, and you're talking about you're talking about giving your name and providing insurance or registration, whatever they require in your state. Gatscat says, can I get a Maddox Lost for my cousin tuning in? Maddox Lost, Maddox Lost. Absolutely. So, again, what you have to answer is beyond those basic identification questions. So what you doing tonight? Yeah, I don't need to answer that. I'm not going to. That's fine. Where are you coming from? I don't need to answer that either. Where are you going? I'm not going to answer any of your questions. But the weird thing is, when you start answering questions and then they ask, is there weed in the glove box? And you say, well, I'm not answering any questions. I mean, you can do that. You can do that. But that sets off alarm bells. And frankly, even though it's not legally supposed to, so does you saying you're not going to answer any questions. But that's the legally safe option. Hopefully that helps. Gatscat says, am I being detained? Yes, you are being detained. The moment you're pulled over, you're detained, period. All right. But, yeah. Don't lie to cops. Just don't answer their questions. You often don't have to. And if you think you have to, for whatever reason, here's the other magic word. And I will not answer questions without an attorney present. Period. That's it. That's the magic. Again, especially if you have weed in your car, don't answer a word without an attorney present. If you are unsure whether or not you have to answer, I won't answer without an attorney. They have to give you a phone book and help you find an attorney. If you can't afford an attorney, they have to provide you one. That's how it goes. And then they smelled weed. They always smell weed. The cops have the best sense of smell ever. The specific context is that I had a tiny little box that I was hastily packing my weed into, and the police and the people I was with were illegally drinking alcohol that they definitely saw. Don't answer questions. Don't answer questions. Gatscat says, in Canada, if an officer says, is there weed in the car, can we just answer yes? Probably. I don't know actually what I wouldn't, because there's probably still a law about being under the influence of marijuana and driving. And if you answer yes to there being weed in the car, that may give them grounds to test you or search you further and cause you a lot of distress. But I can't give Canadian legal advice because the Canadian legal system is weird. All right, guys. I've got, I think that covers it. I think that covers it. As always, thank you for joining me tonight. I really appreciate it. I'm not entirely sure what subject we'll cover tomorrow. Follow me on Twitter. We've got a couple prepared videos coming up very soon. But I wasn't actually going to do a live stream tonight when my Greer partner fell through, but I remembered that I had this and wanted to talk about it and thought this would be great to do it. So we did that. We did this case that I've been wanting to do since I saw it because it's just gross. And tomorrow we will have something. Friday we'll have something. But there are prepared videos coming out, so it is possible that one of the nights I won't do a live stream. I'm just not sure where that will be. Gay and Still at Large says, hey, Nikki Rack. Been a while since I've caught a stream live. Always a blast. Also, which 40K game should I get since your Discord alerted me they're on sale and I have Christmas money? Dawn of War 1 is great and all the expansions, except for Soulstorm's a little weird. But certainly up to the 4th expansion, I think it was. Dawn of War 2, great. A little bit different as well. I like Space Marine, and people have been playing Space Marine again. Eternal Crusade is garbage. Warhammer 40K Inquisitor has some hope, but it's a little slow for an action RPG. I kind of have fun playing it from time to time, but you can't. It's not like a Diablo where you can play a lot of it in a row, in my opinion. The Dawn of War 1 and 2 are great, and the expansions. Dawn of War 3 is trash, and avoid it like the plague. Gojirify says, is there weed in your car? I don't know. Do you consider the wheel well as inside the car? Nope. Don't ever say that. Jamie Hughes says, Nick, I have a bet going. What you drinking? Jamie. Hi, Jamie Lynn Hughes. I have Milo's sweet tea right now, and I just finished some Hennessy White cognac. And before that, I had some Fid Street gin, which is a Hawaiian gin. I hope whatever it is, I hope you win the bet. So, oh, Mechanicus. Mechanicus might be good. I haven't played it yet. I have it, but I haven't played it yet. And then I've also played a little bit of Battlefleet Gothic Armada, and that one's cool. I just suck at real-time strategy. Just ask the cop if they have weed in their car. There you go. All right, guys. Let's wrap it up. Thank you so much. You were right. Good. Good. I hope you win the bet. Thanks for joining me. Join me tomorrow. Join me Friday. Live. The defamation series is coming. I'm hoping to start releasing them over the next couple days. Where Tiger Ray says no Vermintide mentioned. He said 40K. Vermintide is not a 40K game. Vermintide is fun, although it gets very repetitive very quickly, in my opinion. Although they did some updates and the hammer is better, so I might start playing it again. I don't know. Vermintide is very, very fun. It's like Left 4 Dead, but with Warhammer. Old world. All right, guys. Thanks for hanging out. Peace. Hope you have a nice, lovely day. I hope you had a wonderful Christmas. And follow me on Twitter if you don't. And that'll help you know what's going on. Kex7Go says, Mechanicus stream when? Soon, buddy. Maybe. Hopefully. We'll see. We'll see. All right. Talk to you guys later.